Ladies and gentlemen, it's a pleasure to be here, and please let me present brief remarks on the issue of simplification of evidence using modern technologies for the protection of children in criminal proceedings. We can distinguish, I should move this, okay. We can distinguish two general aspects in which the welfare of child participation in criminal proceedings, or more precisely in evidence procedure, could be endangered. In both situations, the simplification of evidence could be very helpful, but at the same time may raise obvious concerns. Now, the first situation is in which the child is taking part in the evidence, where simply the child is being interviewed as a witness. Regarding that, the most important role, generally speaking, should be not to secondarily victimize the child. It is mainly the question of quality of evidence then, as we speak about simplification here. Secondly, it should be noted that sometimes the trial could negatively influence the children's well-being, even if the children are not taking active part in any evidence issues. The length of the proceedings, the extended period of uncertainty could be a problem itself. That is why the crucial circumstance, obviously from the point of view of the child's protection, is to accelerate the process of taking evidence. Therefore, it could be said that the first perspective of simplification deals with the problem of the quality of evidence, how are they taken, and the second issue is emphasizes the quantitative aspect of the proceedings, mainly also the aspect of the time and speed of proceedings. Of course, not yet. Those postulates are formulated only in the view of the child's safeness, and which is not the only value protected by the criminal proceedings. Obviously, it should be balanced with other principal rules, especially the defendant's right to defense. But at least in my opinion, child's participation in criminal proceedings, participation of this very special entity that needs this extra care, may be an additional boost every time we think about introducing something new into criminal proceedings. Because normally we are afraid of some changes because of some principal rules may be somehow infringed. And that's obviously is a very important aspect. But when a child is taken into account, we've got this extra important rule. And that may be a good standpoint for thinking about any type of development of criminal proceedings in the future. Generally, at the level of international or supranational legal regulations, we have commonly known two instruments that could help to improve the hearing of children taking evidence, including children interviewing, which is obviously one, the recording of the interview, and the second one is interviewing with use of special means of communication, which is simply doing it online. And without going into details due to the time of my speech, just let me briefly mention those two European law directives from 2011 and 2012. The first one gives the strong suggestion about the possibility of video recording of the hearing, and the second one state this possibility of hearing in the courtroom without being present there, in particular for the use of appropriate communication technologies. In Polish law, we obviously implement those two suggestions or requirements for Polish members of the conference, that's quite obvious. For other members, just brief remarks. In Polish law, we have two basic regulations of Article 185A and 185B concerning hearing children, taking evidence with children in criminal proceedings. And they mainly base on two requirements, two types of requirement. One, to make this hearing as short as possibility without any doing it over and over again, to do it only by the court, to record it for future purposes, to do it in absentia of the defendant. And the second issue is doing it through these possibilities of now online communication. And that's well-known regulation, as we may do some basic comparative analysis. We've got it widely used in Great Britain, in Czech Republic, as I checked, and so on. Oops. Okay. Now, these were those simple elements. Now, please allow me to move to some controversies. As I was thinking about this topic, as I was thinking about how can we simplify the criminal proceedings for the sake of the children, yes? What can be introduced to speed it up, not to victimize children more than necessary, in the best scenario to avoid that victimization through the proceedings at all. And obviously, I've been thinking about AI instruments. But before that, I made a step back and thought, what about polygraph? Yes. Modern technologies using polygraph also use some constructions of AI elements. But AI is something really new. I will say a few words about it at the end. But we have much older instrument, which is still very controversial, but may be extremely helpful in speeding up the proceedings involving children or helping to avoid making a child the central witness of the proceedings. Just a few remarks here. The polygraph examination is obviously quite an old technology, and in Poland we've got some research on that and usage even from the 1970s. The evidence, of course, under some limitations, under some conditions, was accepted by the Polish Supreme Court. We've got even an old decision there from 1976. At the same time, it is highlighted that it should be treated as subsidiary evidence. Modern technologies of polygraph tend to be extremely efficient. In the same time, from this Polish law perspective, I mainly speak about the Article 199A. There is no such thing as evidence from the polygraph. We may use an expert's opinion, and the expert might be supported by this more or less complicated device. So it's never actually the statement coming from the machine, but it's the expert's analysis who's supported by that element. But still, the usage of such instruments is extremely rare. Obviously, under our legal requirements, it may be used only with the consent of the person which is to be polygraphed. So, taking it back to the situation concerning trials, cases involving children. Yes, let us see a criminal proceedings where there's an obvious conflict between parents. That is unfortunately a very common situation. And usually the court has two versions of events presented by both parents. At the same time, quite often the trustworthiness is rather low, generally get there. And in such a situation, the child is in extremely difficult position because the child is that third person who's to be treated as the most important witness. So perhaps the possible measure to reduce that burden put on a child as a witness could be a wider usage of polygraph examination of one of two parents. Um, so there is an instrument already possible, yes, already having its support under criminal law regulations that may be used and may be used as such a standpoint for possible further simplifications. Now, obviously the very hot topic is the usage of AI instruments to speed up proceedings, to remove this harm of the long time involvement of the children, the direct and indirect in the proceedings, and just to signalize the obvious problem. When such a technology develops very fast, we obviously still lack enough legal regulations there. In Poland, we obviously lack uniform, standardized requirements of the possibility of using it in criminal proceedings. What is more, we in Poland now we don't even have one centralized standard concerning using certification of experts, including experts using AI for the purposes of criminal proceedings. So just to sum up and to leave this open question also to you, is that maybe this aspect, this need of protecting children from unnecessary burden of criminal proceedings, often obvious trauma involving the participation, even the indirect participation in the proceedings, maybe this additional point for the discussion about why they're introducing AI instruments to the criminal proceedings, mainly to speed it up. Yes, but that creates a whole bunch of problems, of issues, among which the central problem is obvious. Where will we have a situation when there is an expert supporting his specialized analysis with an AI instruments simply to work faster, for instance, analyzing some pictures or whatever, and when there is an AI algorithm actually creating evidence or being being piece of evidence by itself. So I leave you with that open issue, and that's the last one. Thank you.